As I mentioned in the previous video, there's very often an important issue involving the interpretation of an employment contract as to whether it complies with minimum standards legislation. So every jurisdiction in Canada has an Employment Standards Act that sets out minimum entitlements on termination of employment. Ontario is the most generous of those statutes in that it has a provision for termination pay, that is notice or termination pay, as all the other jurisdictions do. Plus, Ontario has a severance pay obligation of 1 week a year to a maximum of 26 weeks, where payroll exceeds 2.5 million and employment is over 5 years. Ontario also has a requirement to continue all benefits for the notice period, which caps at 8 weeks, which other jurisdictions do not have. Ontario also has a difference in the standard of cause that's required to avoid the statutory payment as opposed to the common law. Now, all those issues that I've described are very often reasons for disputing the employment contract. If, for example, the employment contract does not comply with the minimum payments due on termination of employment, then the termination provision is not going to be binding and the claim will be determined by common law standards. Let's say also the agreement does not distinguish between the type of just cause required to avoid the statutory payment and the common law. The statutory payment degree of cause to avoid that obligation by the employer is summarized as being bad on purpose, basically willful misconduct, whereas the common law does not have such a high standard. So if the employment agreement does not distinguish between that standard of cause to avoid the statutory payment as opposed to the common law, then the entire termination paragraph is going to be unenforceable. Similarly, if the agreement does not continue all benefits for the required notice period, the termination provision also may be tossed. There's also a further argument raised recently by an Ontario case that if the agreement says the employer may terminate any time as it wishes, subject to the payments that follow, etc., then that also is in violation of the Employment Standards Act, which has certain protected leave rights. And that phrase has been determined by a trial decision, not a court of appeal decision, to render the termination paragraph unenforceable. So it's a pretty tough onus for the employer to meet these things. If you're facing an employment contract, you should be aware of these issues. I've detailed all these issues in a summary that's attached in the description below. But generally speaking, it's a difficult issue for the employer to enforce the employment agreement, and care should be taken when a challenge is made by you as the employee against it, because there's a lot at stake. So I recommend you get legal advice. Again, I'm not practicing law, and if you need a lawyer, call me. I'll make sure you get one, or email me, and we'll discuss other issues of the employment contract shortly.